New Jersey estate planning. The difference between a conservatorship and a guardianship. As families in New Jersey face the realities of aging or disability, understanding how to protect a loved one's well-being becomes paramount. Individuals with dementia, Alzheimer's disease or other impairments may struggle to handle daily living or make financial decisions. Parents of young adults with special needs often discover they cannot access medical information or arrange care because the law treats 18-year-olds as adults. When informal caregiving is no longer enough, state law offers two formal routes: guardianship and conservatorship. Guardianship is a court process for appointing someone to represent a person who is mentally incapacitated. To start a guardianship, an interested person files an application alleging the individual cannot manage their affairs, and recent certifications from 2 physicians or 1 physician and a licensed psychologist must support the claim. The court determines incapacity and reviews whether the proposed guardian is qualified. Once appointed, the guardian must act in the ward's best interests and honor the person's known preferences. Guardians make decisions about where the individual lives, what medical treatments they receive and other day-to-day needs. Courts may require specific approval for extraordinary treatments, and the judgment defines the scope of the guardian's authority. The guardian is usually a spouse, relative or trusted friend, but lawyers, private organizations and state agencies can also be appointed. By contrast, a conservatorship focuses on managing the person's finances. Known as a guardian of the estate, a conservator is responsible for collecting income, managing assets and preserving their value. Unlike guardianships, New Jersey conservatorships apply only when the individual has not been adjudicated incapacitated and consents to the appointment. If the proposed conservatee objects, the court will not appoint a conservator. Conservators must make necessary payments for education, support and maintenance, pay legal debts, collect and manage assets, collect sums of money due, pay taxes, and participate in estate planning. They must prepare regular accountings and generally cannot write a will on behalf of the individual. New Jersey allows a person or agency to serve as both guardian and conservator, known as a plenary guardianship, but when they are different people, the guardian of the person retains ultimate control over personal care decisions. If there are insufficient funds to cover necessary care, the court mediates the conflict. Understanding the differences between conservators and trustees can aid estate planning. A conservator is appointed by the court to protect an incapacitated adult's person and/or finances, making decisions about health care, living arrangements, and financial management. A trustee, however, is chosen by a competent individual to administer a trust according to its terms, manage investments and distribute income or principal to beneficiaries. Thus, a conservator acts out of necessity due to incapacity, whereas a trustee is pre-selected to carry out the grantor's wishes. Guardianships and conservatorships can be contested. Sometimes the individual or another family member objects to the appointment, leading to difficult litigation. The Matus Law Group notes that prolonged litigation is not ideal and offers mediation to help families reach a fair solution. When does the relationship end? A guardianship concludes when the court restores the person's capacity, when the person dies or when the guardian resigns or is removed. The guardian must then deliver the will to the surrogate, complete a final accounting and wrap up remaining tasks. Guardianships for minors end when the child turns 18. Conservatorships end when the conservatee requests termination and the final account is approved or automatically if the conservatee dies or is later found incapacitated. Knowing whether to pursue a guardianship or a conservatorship depends on the individual's needs. Guardianship is appropriate when someone cannot manage daily living and requires someone to make personal and medical decisions, while conservatorship is suited to protecting financial interests when the person can consent but needs assistance. Consulting a lawyer early can prevent confusion and ensure that the right tools are used. A seasoned attorney can guide families through the requirements, prepare the filings and ensure compliance with court rules. Lawyers at the firm caution that Social Security often uses a representative payee and Medicaid allows an authorized representative, so a conservatorship is not always necessary. An experienced attorney from our law firm can also help restore or end these arrangements when circumstances change. For families confronting the complex issues of guardianship or conservatorship, legal counsel is invaluable. Speaking directly with a lawyer ensures that questions are answered and that a tailored plan is developed. This law firm's lawyers understand that each situation is unique and requires thoughtful planning. The Matus Law Group, located at 125 Half Mile Road No. 201A, Red Bank, New Jersey, 07701, provides guidance with compassion and integrity. Reach the law firm at 732-785-4453 for advice on establishing, contesting or ending these protective arrangements.